Hello and welcome back to another video on misrepresentation under the contract law unit for OCR. What we're going to cover today is the test for misrepresentation, the three types of misrepresentation and how to apply this to a scenario. So misrepresentation is a vitiating factor which makes a contract void or voidable. So a contract is void if it's got no legal standing in the first place, whereas voidable means that it in principle still stands, but you can take it to court and make an argument that it should be voided. So it's voidable. There are two main types of vitiating factors on the OCR specification. That's misrepresentation and economic duress. This presentation is going to cover just misrepresentation. So a misrepresentation can only occur when a contract's being formed, essentially, and you need to know the difference between a representation and a misrepresentation really to begin with. So a representation is a statement; it's something said that influences a decision on whether or not to make a contract. It's not a term. So representation is something just said when sort of making a contract with someone. So a misrepresentation is a representation that's false, essentially. It's a misrepresentation. And the effect of a misrepresentation is it makes the contract voidable. And as I just said, voidable means the contract is valid, but you can take it to court and argue that the contract should come to an end. And ending the contract is known as rescission. So there's a four-part test for establishing a misrepresentation. Number one, it has to be a false statement, it has to be a material fact, it has to be made by a party to the contract, and it has to induce the other party to enter the contract. And you need to tick all four of these for there to be a misrepresentation. Starting with a false statement, the statement made must be false. So you have to say something that's not true. Now, the extent of the person's knowledge of the accuracy or the truth of that statement will impact what type of misrepresentation it is later. There's three types: fraudulent, negligent, and innocent. And obviously, the person's knowledge as to whether it's false or not will depend on what it ends up being, if it is indeed a misrepresentation. Because there has to be a statement, silence can't be a misrepresentation. And we can see that in the case of Fletcher v. Krell, where a woman applied for a job as a governess. She was not asked at any point during the interview, and she didn't say she was divorced. And in Victorian times, it's 1873 this case, that would have meant that she wouldn't have actually been offered the job. But she was never asked, she didn't say. The court decided there was no misrepresentation. She was under no duty to disclose her marital status. She was under no duty to just tell everyone that. And she wasn't asked about it, so she didn't lie, she didn't make a false statement, so therefore it wasn't a misrepresentation. So just to be clear from this, silence can't be a misrepresentation, and importantly, there's no obligation on a person wishing to enter a contract to make any statement about what's being offered. You don't have to say anything. So you're not under an obligation to say anything at all, but anything you do say has to be true, it can't be false. So if you get a scenario where someone wants something for something, they want to buy a particular item for a particular reason, but the person you're buying from doesn't say anything, that's not necessarily a misrepresentation then, because silence isn't necessarily a misrepresentation. So there are exceptions to this rule, of course. So there are a couple we're going to look at here. So these are where silence can actually be a misrepresentation, but they're very specific. So the first one to the far left of this page, silence can be a misrepresentation where the situation has changed between making the representation and acceptance of the offer. So in With V. O'Flanagan, a doctor accurately stated the profits of his medical practice, his doctor's surgery essentially, made with a view to inducing the purchaser to buy the practice. So he said what the profits are, because obviously that's going to be relevant to the person wanting to buy it. However, between the statement and the contract being made, the doctor fell ill and many of the patients left the practice, and therefore that significantly decreased the profits that actually that doctor's surgery, that medical practice was making. And that made the original statement therefore inaccurate, and the court decided he essentially actually should have told the purchaser before the contract was signed that was no longer true and the profits were therefore different at that point. So if the situation changes before the contract's made, then you are expected to update that. You can't be silent on that change. You've got to say something. Silence can also be a misrepresentation where a statement made is a half-truth. That's the middle one there. So in Dimmock v. Hallett, a seller of land told the purchaser truthfully that there were tenants on the land, And the purchaser said, great, that's what I want. But what the person didn't say was, oh, by the way, they're actually going to be leaving soon at a certain point. So he answered half-truth in the fact that, yeah, there are tenants, but what the person was actually asking are there tenants that are staying? So he only told a half-truth, and therefore that was a misrepresentation. The final one on the far right there, silence can be misrepresentation where there's a relationship based on trust. So, for instance, in this case, it was a financial advisor. In Tate v. Williamson, a financial advisor advised his client to sell some of his land off for sort of less than half its value so that he could clear his debts. But what he didn't say was he was actually going to buy the land. And that's clearly misleading and was that silence, that not actually mentioning that he was going to buy it, was a misrepresentation. Some more here. So on the left here, silence can be a misrepresentation where there's a contract of utmost good faith. The most common types of these are insurance contracts. So Lambert v. Cooperative Insurance Society. A woman renewed her insurance policy but failed to actually mention that her husband had been recently convicted of conspiracy to steal. An insurance company, if they'd known that, they may not have offered her insurance, or they certainly may have charged her a lot more for the insurance. And the court decided that was a misrepresentation, as it's a contract of utmost good faith. You're expected in contracts of utmost good faith to be honest from the utmostly, just to absolutely say what they're actually going to want to know. Now, this has slightly been impacted by the Consumer Insurance Disclosure and Representations Act in 2012, and that act provided guidance to insurance companies, for instance, about what they actually have to say. So they are under an obligation to ask customers now the certain questions like this. So they don't just necessarily have to wait for the person to say it. They'll have to actually say, have you or anyone, your spouse, etc., been convicted of these crimes? So then if the person says no, they're obviously lying, and therefore that's clearly a misrepresentation. But you're not expected nowadays just to actually know to say. The insurance company under that act should be asking you. Silence can be a misrepresentation through actions. So Spice Girls v Aprilia World Service, BV. The Spice Girls had signed a sponsorship agreement with Aprilia, but whilst it was being negotiated, Geri Halliwell, one of the Spice Girls, gave notice that she was going to leave the group. What they all then did, though, was attended a promotional filming session for merchandise, which wasn't actually going to clearly be able to be used once Geri left the band, but they didn't say anything. They all just turned up and carried on as normal, and the court held that the fact that they all turned up, although they were signed, no one actually said anything, they held that was a misrepresentation, the actions essentially. So, second part of the test is that the misrepresentation must be of a material fact. So it has to be, you're saying a fact, not an opinion. So in Bissett v Wilkinson, the seller of farmland that had never had sheep on it was asked by the buyer how many sheep you could fit on it. And although he wasn't a sheep farmer, he said, well, maybe around 2,000. And that turned out to be false. However, as he genuinely believed his opinion to be accurate, they said it wasn't a misrepresentation. It was he was giving an opinion. How would he know? So it's got to be a fact. It's got to be something that you actually know and you're saying, and the person knows you know. So it can't just be they're asking your opinion. That wouldn't be a misrepresentation. The statement has to be made by a party to the contract or an agent, so someone that works for them, for instance, perhaps, but it's got to be made by a party, so it can't be made by a third party. So if you're buying something online and you read a review and it says it does something, and then you get it and it turns out it doesn't, that misrepresentation, that lie, that false statement wasn't made by the party you're buying it from. It was by a third party on a review, so that wouldn't be a misrepresentation. And the final bit of the test is it has to induce the other party to enter the contract. It's got to basically make you want to enter that contract. So it's got to be a critical part of making that decision. And the statement must be important to the person making the contract. They must have relied on it and they have to have relied on the statement made rather than their own judgment, or particularly information obtained elsewhere, as you can see in Outward v Small. So the seller of a mine made a false statement to the purchaser about earnings of a mine. They said it was making this much, it wasn't. The buyer actually then instructed a surveyor, rather than just relying on that, they hired a surveyor to check that, and that surveyor did, but got it wrong as well, unfortunately. The purchaser bought the mine, found out to be true, and then sued for misrepresentation, but the court said no, it wasn't, because you didn't. Yes, okay, it was a false statement. It was a fact because of how much it was actually earning, and it was made by the party to the contract. But this one, it didn't induce them because actually they didn't rely on that. They actually then relied on the surveyor's confirmation, and just turned out that would be wrong. So they would have had a claim against the surveyor for getting it wrong, clearly, but not for against the other company for misrepresentation. So it doesn't matter if the victim could have discovered the truth by taking reasonable steps, or if it was perhaps even unreasonable to rely on that untrue statement. So in Redgrave v. Heard, the purchaser, and this is relevant to the fourth rule still, the purchaser of a solicitor's practice was given a set of accounts to look at, and the seller verbally misled the purchaser, so they said a statement that was untrue about the earnings of it. He relied on that statement. He didn't even look at the accounts, which he could have, but he didn't. And had he done so, he would have realised it was false, but he didn't. He relied on that statement that was said, and the court said that that was enough. That was a misrepresentation. Although he could have discovered the truth by taking reasonable steps, there was a misrepresentation. Equally, in Muse-Time Properties v. Adhill Properties, the purchaser of property relied on inaccurate statements about rents made in some sort of auction pamphlets, essentially. And the defendant said that no reasonable purchaser would have relied on those. That's ridiculous. That's so unreasonable. But the court said, as the purchaser did rely on them, there was a misrepresentation, or there certainly could be a misrepresentation. So in terms of once you've established the test, so established whether a misrepresentation has happened or not, you then need to establish whether it's an innocent, negligent or fraudulent misrepresentation. Now an innocent misrepresentation is covered by the Misrepresentation Act, nice and clearly and easily, and that clarifies the definition of innocent misrepresentation as one which is genuinely held on reasonable grounds. So you genuinely, on reasonable grounds, believe it to be true. What you're saying, the false statement. So it's something made honestly. You always believed it to be true. Now, in this situation, the remedy available to you, if the court agrees that it was a misrepresentation, is either rescission, so ending the contract, or damages. And it's up to it's the court's discretion, as stated in the Misrepresentation Act, as to which to give. But notice that you can only have one or the other there. Negligent misrepresentation is a bit more complicated. It was only actually introduced in 1964 in the case of Headley, Byrne v. Heller, and that introduced the idea of it. So this is where a false statement is made by a person who's got no reasonable grounds for believing it to be true. So they're not lying, but they actually they did have the truth really and could have said the truth, but they just had they didn't find it. And you can see that in the case to the left there of Howard Marine v. Ogden and Sons. I'll go through in a second. So under Headley, Byrne v. Heller, so there's two ways essentially of trying to make a claim for negligent misrepresentation. You can either sue under Headley, Byrne v. Heller, and the claimant has to prove that there was a misrepresentation, and they have to prove that the defendant was negligent. However, under the Misrepresentation Act, another way of suing for misrepresentation, for negligent misrepresentation, the claimant must prove that there was a misrepresentation, and then the defendant must prove they were not negligent. So clearly there's I would imagine rather sue under the Misrepresentation Act because it's easier as the claimant. You've only got to prove that it was a misrepresentation, and the defendant then has to prove they weren't negligent. And the remedy for this is rescission and or damages, and that's the big difference from innocent misrepresentation. You can have both potentially. Now the case for this is Howard Marine v. Ogden and Sons. Ogden hired two dredgers, so boats, to dredge up sort of the sea floor, lake floor, whatever it was, sea floor in this case, from Howard Marine. Ogden asked Howard for the capacity of the barge, like how much it could fit on it, so how much of like the soil they're dragging up and putting on the barge to dump somewhere else. Howard checked Lloyd's Register, which stated the capacity. So Lloyd's Register is like a register of all like basic things about boats, essentially, and the entry was incorrect. So the entry unfortunately was incorrect in that, and the capacity was much lower, and then the work took much longer to complete. It cost a lot more. They weren't very happy, so they sued for misrepresentation. Now Howard argued that they had reasonable grounds because they said, look, we checked the Lloyd's Register. However, unfortunately, they had the actual registration document for the barge in their office, which they didn't bother to check. So they just randomly checked Lloyd's Register and didn't bother to check the actual proper registration document in the office, which they could have. So that's, yes, it was innocent in the fact that they weren't lying, but it was negligent because they should have just done the job properly and actually checked the proper document rather than just checking quickly the Lloyd's Register. So it was held to be a negligent misrepresentation. Fraudulent misrepresentation, this is where someone basically is lying, or they're giving a really overly rose-tinted view of the situation, but basically they're lying. There's two cases here. Dairy v Peak, so a tram company used horses to pull its trams. It's 1889 in this case. And the directors of the company believed that they would get consent to change them to motor-driven trams, because it was the time that these were coming in, and you had to get consent to do that. You couldn't just do it. And they just assumed that they would get it. They would get the consent. So they was going to make it much more profitable. So they went out for investment into the company on that basis, saying, look, we're going to get these motor-driven trams, invest in us. And then it turned out, so lots of investors did, and then it turned out the company didn't get the consent, and the company shares dropped in values. The investors weren't very happy. They wanted to sue for their losses. Now, in this case, they held that there was no actual fraudulent misrepresentation because the company had genuinely believed that they were going to get the consent. So they were either innocent or negligent misrepresentation, depending on whether they had reasonable grounds to believe it or not, which we won't get into. But in this case, they defined what fraudulent misrepresentation is. So although it's not a case of fraudulent misrepresentation, weirdly, they did define it and basically said it as above. It's lying or an overly rose-tinted view of the situation. And again, the remedy, like fraud, like negligent misrepresentation, is rescission and or damages. So the rose-tinted view you can see to the left there in Greenridge, Luton 1 v Kempton Investments. Buyer of commercial property was entitled to award of damages. They were told that the major tenant had not paid the service charge due to historical issues, is what they were told. But in fact, it was actually a pending dispute between them, and that amounted to a fraudulent misrepresentation because they were lying, essentially, although they didn't outwardly lie, but it was heavily rose-tinted by saying it was historical issues when actually it was a massive pending dispute between them both. So, in terms of remedies, as we said, you can either have rescission or damages or damages for fraudulent and negligent, and innocent was rescission or damages, so you just got to be clear on those differences. Now, rescission isn't always available. You can't have it in every situation. So there's 4 reasons why it's not available. The top left one here is it's impossible. So basically, it's impossible to cancel the contract and return the parties to their original position. You can't do it. And that's a very specific situation. So in the case of Clark v. Dixon, the claimant was misled into becoming a partner of a firm. And basically, the rescission wasn't possible because the partnership had changed to a limited company, and you can't change limited companies back to partnerships legally. So it was impossible to order rescission and to revert back to the original contract position. So you couldn't cancel the contract essentially in that one. If the contract's affirmed, so affirmation is where the innocent party basically finds out there's been a misrepresentation but decides to carry on with the contract anyway. So you then can't later on choose to have rescission or rescind the contract. You can't ask for the court to rescind it later on if you knew there was a misrepresentation and chose to carry on. So in Long v. Lloyd, the claimant was told by the seller that a lorry was in excellent condition, but shortly after the sale it broke down. They contacted them. The defendant offered to pay half. They said, great, okay, let's carry on. And so they knew they'd lied, but they carried on. It then broke down again shortly afterwards, and the claimant took them to court to say, I want misrepresentation, I want to rescind the contract. And the court said, no, you can't have rescission because you affirmed the contract when you agreed to half the repairs, so you can't have rescission now. Another reason why you can't have rescission is if a third party has gained rights over the property. So if someone else has the goods now, it wouldn't be fair to then take them off that person and give it back to you, for instance, if you're the person suing. So in Lewis v. Avery, Lewis had sold his car and he let the buyer, who actually turned out to be a fraudster, take the car away in exchange for a cheque. The fraudster then sold the car onto the defendant, so onto essentially another person, onto a third party, sorry. So the original seller's only effective remedy was to claim rescission and ask for the car to return to him by the innocent third party because they couldn't find the defendant. And the court said, well, no, that's not fair. This innocent third party has got this car in good faith, so it wouldn't be fair to let them have them. So just to be clear there, Lewis sold the car to the fraudster disappeared, couldn't find them. They'd sold the car onto this other person, and then Lewis wanted to get this car off to this other person, but the court said that's not fair because they're a third party. They've gained rights over it. It wouldn't be fair to order the contract to be cancelled and give it back to you in that instance. And finally, delay. The longer and longer it goes on for, the less likely a court will order rescission. So in Leafy International Galleries, a claimant purchased a picture of Salisbury Cathedral from the defendant and was told it was done by the artist Constable, but found out later when he tried to sell it 5 years later, but it wasn't. And the court said, no, you can't have rescission in this instance because it's been too long. So when you're applying this to a scenario, the first thing you need to do is establish whether there has been a misrepresentation. So you want to apply the test here. And then once you've done that, you want to decide which type it would be, whether it's an innocent, negligent, or fraudulent misrepresentation and why. Obviously, you can sue under the Misrepresentation Act for this one. You can choose here, and this one you can sue as well, obviously whether it's an outright lie or a rose-tinted view. And then you need to establish what the appropriate remedy would be. So be clear here, is it rescission or damages? With these, you can have rescission and or damages, and this on rescission and or damages as well. But also bear in mind that rescission might not be possible based on those 4 factors we just looked at. Hope you found that video useful. Please like and subscribe for more videos from the A-Level Law Teacher. Thank you very much.